Whenever appellant's ready, you may proceed.
May it please the court, my name is Okorie, O-K-O-R-I-E, last name Okorocha, O-K-O-R-O-C-H-A. Our key point in this case is Meyer got a set aside of the default judgment. He was properly served by certified receipts signed by Mr. Meyer, and he does not dispute this. He also appeared with an attorney in the judgment collection action when this judgment was domesticated in Nevada. And so he, I don't see if I have the lawyer's name, but he did appear with a lawyer, and under the, what do I call it, the farmer's case, a general appearance in a post-judgment action, a general appearance is an appearance for purposes of curing all defects. He also, was found to be evading service, but, people would, the process servers would go to his residence, and a female would answer and say, "Oh, let me go get him." And then she comes back up. He's not home after all. And the process server went there 5 times. Now, shortly after all the briefing was finished, he filed a declaration saying he does live at that Nevada address that we were trying to effect the service on. He never once disputed his signature was on the United States Postal Service certified mail receipt. So there's many reasons, including he had 6 different attorneys in his post-judgment appearances in the same case.
And where were those post-judgment appearances? Were they in California or Nevada?
Nevada.
Okay, thank you.
And this case, just for background, arises out of the respondent doing illegal contract work in California where he was not licensed. And he is, in his response, kind of makes ad hominem attacks on my client. My client's record was wiped clean because I argued that case. I think it's the same courthouse, and we were successful in having, factual innocence, or we wiped it clean in some fashion. So he doesn't have any of the felony convictions. The trial court was correct in its original tentative, but somehow we got off the subject. I want to give one cite. A general appearance made after entry of judgment has the effect of curing any defect arising from the lack of jurisdiction due to failure to serve or notify a person of the proceedings, and a citations, and a judgment based upon such an appearance is valid in its Farmers, etc., National Bank versus Superior Court, and it's been the law since 1945, 25 Cal 2nd, 842, pages 846 to 847. So either way, there's a general appearance anyway, which cures any defect. And third, or second, he's never challenged that he signed for the, service with his signature on a certified mail. He's never disputed that. And then he transfers the house into a spendthrift trust to avoid collections. And now he files a declaration saying that he lives at that house after all. And that was filed the 3rd day of June in 2025 in Nevada.
Is that in our record?
No, because he filed it after the briefing. And that's all I have. I'd like to reserve for rebuttal.
Certainly. Thank you.
Good afternoon, Your Honor. Ruocheng Liu for respondent Michael Mayer. It's Ruochen. Last name is Liu. So I think the order should be affirmed for several reasons. Firstly, appellant's procedural errors preclude him from arguing the factual merits. Appellant Moran filed 3 separate oppositions. He failed to appear at the September 12, 2024 hearing and never objected to the evidence. Since appellant didn't show up, he waived his right to argue any facts. Appellant failed to file a request for judicial notice at the trial court, so he waived his right for judicial notice. And plus, on the same date that the mini order was emailed to the parties from the court, appellant Moran filed a notice of appeal prior to awaiting the 5-day requirements of California Rules of Court, Rule 3.1312. Therefore, appellant Moran prematurely filed his notice of appeal prior to allowing anyone to file a notice of entry of order. So the court order became a non-appealable order. Therefore, there is a question of appealability.
If we get beyond the appealability issue, how do you respond to his substantive arguments?
Are you referring to his alleged Michael Myers actual notice,
Yes.
actual knowledge of the?
Yes.
I think it's irrelevant because appellant counsel, he improperly seeks to admit new evidence and facts that do not appear in the record, but are asserted in a brief, including allegations regarding appellant's Nevada lawsuit and supposed knowledge of the California judgment by respondent Mayer. And the facts or documents not in the record must be disregarded.
The Nevada address was in fact your client's address, correct?
I don't think so. His actual address is in Orange County, based on my knowledge.
Okay, so he did not own that property? He did not live at that property?
That property is used to be owned by his family trust.
But he did not live there, is that
No.
correct? Okay.
May I continue? Okay. And secondly, the record demonstrates fraudulent and defective service. Appellant Moran filed a false and frivolous lawsuit against Meyer, improperly serving him at an out-of-state address by certified mail instead of his Orange County residence, and using a property owned by Meyer's family trust. Moran then submitted a fraudulent proof of service by mail in place of the mandatory POS 10 form, falsely claiming a mailing date 30 days earlier than the actual USPS tracking date. Even worse, the judgment was entered before summons. The judgment was recorded on January 3, 2022, 6 months before the summons was even issued, making the judgment procedurally impossible. And
I'm
Third-
sorry, Ms. Liu, could you repeat that point? I was taking notes and I think I missed something.
Okay, no problem. Moran, he submitted a fraudulent proof of service by mail instead of the mandatory proof of service 10 form.
You mentioned something about something happening before the summons had been issued? If I heard you correctly, I may have missed that.
Yes, Your Honor.
Could you tell me that part again?
Because Moran, at that time, he submitted a fraudulent proof of service by mail, but he's supposed to file the mandatory proof of service 10 form. And he claimed a mailing date 30 days earlier than the actual USPS tracking date. So he has a behavior pattern of making the fraudulent statement about the proof of service.
She mentioned something about 6 months, it was served 6 months before the judgment was entered. I thought I heard that as well.
Yes, the judgment was recorded on January 3, 2022, 6 months before the summons was even issued. The summons was issued on July 13, 2022. So there's a discrepancy.
It's your position that the judgment was entered before the summons was even issued?
Yeah, that's a fact.
Okay.
And thirdly, respondent's motion was timely under CCP section 473.5. Respondent filed his motion on July 2, 2024. It's well within the 2-year statute. Respondent Meyer's motion to set aside was based on CCP section 473.5, not under section 473. It's a 2-year deadline to file a motion to set aside, not 6 months, because the judgment is based on extrinsic fraud, not based on excusable neglect. Even the appellant can prove the respondent has knowledge of the judgment before. The motion to set aside was filed timely, well within the 2-year deadline. What's more, appellant never filed or served a notice of entry of judgment, so the deadline never began to run.
I'm sorry, you said it was within 2 years, but you just told us that the judgment was entered in January of '22, and the motion was filed in July of '24. So perhaps I'm mishearing you.
Respondent Mayer, he filed motion to vacate on July 2, 2024. It's well within the 2-year statutory period.
2 years after the judgment is entered.
Within the 2-year statutory period of the judgment.
Right. And you also told us that, let's see, the judgment was entered on January 3, 2022.
No, the judgment.
From our record, it looks like the judgment might have been entered in January 2023. Is that what you
Oh,
mean?
sorry, it's January 3, 2023.
Okay, all right.
And finally, policy strongly favors trials on the merits. Where service is defective, courts must err on the side of protecting defendants' rights. The trial court carefully reviewed evidence, relied on multiple grounds beyond service defects, and exercised its discretion properly in granting relief. So for these reasons, we respectfully request the court affirm the order setting aside the default judgment.
Thank you.
Thank you.
Reply?
Your Honors, I'm not going to take up any time responding to the allegations of fraud because somebody used the wrong proof of service form. Because talking about things that have no merit too much can start to make it seem like there's some merit there that one is debating. The ruling, the minute order of the court said it was sought under 473D, and that, that's only if it's void as a matter of law. But I believe the court, Meyer originally tried to set aside the default under 473.5, but the judge converted it to a CCP 473D, it looks like. And the other, arguments are more form over substance. I don't know what else my client needs to do to serve this guy when he has a signed certified mail receipt and the guy appeared with a lawyer in the Nevada courts. That's a general appearance. It wasn't a special appearance to challenge jurisdiction. That wouldn't be an appearance, but he appeared in the action with 6 different attorneys. So to say he was unaware, why was he there then? It just doesn't make any sense. But I'll just leave it there because the personal attacks and stuff just showed as I believe Justice Sills said, just showed the paucity of your own arguments. Thank you.
Thank you.
Thank you.
Thank you to both counsel. Matter is submitted. Oh, no, we're done. The matter's been submitted. Thank you. People versus International Fidelity Insurance Company.